Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 48th lecture where we are going to deal with one of the leading cases. And as far as the lecture is concerned, so far 48 lectures, we have dealt with practice and procedure, Supreme Court practice and procedure, drafting, then professional ethics also. But as far as the leading case is concerned, this is the first time we are going to deal with the leading case. So it is our regular practice that we recite preamble of the Constitution before we start with the topic. So I request each one of you to recite preamble along with me, because we strongly believe that preamble our goal and preamble our soul. So we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. I just now said that this is our lecture number 48 and we are going to deal with the leading case. Before going to a leading case, let me ask few questions to myself. First is, what is leading case? The second question is, what are the study materials or the source of the study material? Where will I get it? Number 2. Number 3, how am I going to prepare and write the examination? So third question is coupled with 2 questions. How am I going to prepare for AOR examination, and how am I going to write the answer sheet? So these are the 4 basic questions that I have asked myself, and after answering this, I will take you to the leading case. The first question is, what is leading case? To put it in a very simple way, what is the difference between an ordinary student and an extraordinary student? The ordinary student who prepares for 6 hours for his examination, the extraordinary students prepares for 12 hours. And with respect to the leading cases is concerned, which is a leading case and what is the difference between normal case and a leading case? The name itself denotes leading means guiding someone, guiding the cases. So in what circumstances a case law become a leading case law? It is normal case law only. Because of the peculiar facts and circumstances, it becomes a leading case. What are those circumstances where it makes a leading case, a case law as a leading case? Number 1, first is when there is a gray area and there is no law also operating on that particular area. For example, sexual harassment at workplace. Before Vishaka's case, there was no law made by the parliament, no rules and regulations also. But when this case was filed, the Honorable Supreme Court felt that we cannot be a mere spectator by saying that we don't have any law, therefore we cannot enforce it. Because the Honorable Supreme Court is the custodian of the Constitution, protector of our fundamental rights. So therefore, they have held that as far as if there is a law enacted by the parliament, until then we will make our guidelines, and those guidelines will become a law, enforceable law, until the parliament enacts a particular law, consent law. So when there is a gray area, or when there is no law, where the Supreme Court makes a law through guidelines, it is a leading case law. Why? Because it is going to lead and guide the similar other cases. This is one circumstances. The second circumstance is when there is a substantial question of law. Generally, even if you look at form number 28, which deals with format of special leave petition, they have said only question of law, not substantial question of law. So what we urge before the court in our cases, it is only a question of law. So what is the difference between a substantial question of law and question of law? Substantial question of law means which concerns the public importance, which involves the interpretation of the constitution provisions. Therefore, the Honorable Supreme Court as a final arbiter, the Supreme Court interpret the important provisions of the constitution and held that this is what a proper interpretation of a particular provision. They pronounce a authoritative say on a particular case. So they interpret the constitution, they interpret the substantial question of law and give authoritative pronouncement in that particular case. It becomes a leading case. This is yet another circumstance. Number third circumstance is when law is unsettled, a new enactment, law is unsettled, and high courts of various states giving conflicting judgments. For example, domestic violence, protection of women from Domestic Violence Act. Whether such act is a civil law or a criminal law or quasi-criminal, because we found different judgments on this point. Some court said it is only a civil case because application being filed under section 12 of the Protection of Domestic Violence Act. Some has held that it is a criminal case. But ultimately, when there were contradictory judgments on this point, there is an authoritative pronouncement by the Honorable Supreme Court that it is only a civil case. Only when you are disobeying the court's order, thereafter it takes the form of the criminal case, only to the extent when there is a violation to such protection orders. So until then, it is treated as a civil law, civil cases. Even the respondent husband was treated as an accused earlier, but the Honorable Supreme Court has held it is only a civil case. Don't treat him as an accused. Don't compel his presence. He can please be allowed to appear through an advocate like a civil case. So that is what an authoritative pronouncement when there is a conflicting decisions among the high courts. So this is how a case becomes a leading case. Similarly, for example, we sit here as a members of the bar, and people from our own bar, they contest in the election. And when we cast vote with majority, they come out as a successful candidate. So they were normal members of the bar. When they are contesting for the election, when they are getting a good majority, they become a leader. They become our representative. So they are the leaders. Origin is from the members of the bar. So it is normally a case law. Depending upon the circumstances, situations, it becomes a leading case to guide the similar cases. So this is what the leading case means, dear friends. And most important aspect is there are two principles evolving out of this leading case. The first principle is doctrine of precedent. Reason is Article 141 of the Constitution of India. What does it say? When the judgment is pronounced by the Supreme Court, shall be binding on all courts within the territory of India. So shall be binding, it is not may. Shall be binding on all courts within the territory of India. I read, law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. So it is a binding effect. So the Honorable High Court, the District Court, they are bound by the Supreme Court judgment by virtue of Article 141. This is what the law of precedent is. Once it is declared, in similar cases, they need to follow the Supreme Court judgment. And I would like to draw your attention to Article 144 also. Article 144 of the Constitution of India, which deals with civil and judicial authorities to act in aid of the Supreme Court. All authorities, irrespective of any authorities, all authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. So this is very important, dear friends. So we have seen Article 141, we have seen Article 144. I said two principles. One is doctrine of precedent, another one is doctrine of judicial discipline. So this is how you have to narrate when you write your leading cases, because this is basic, common, you can write when you can mold your answer to the relevant question. So doctrine of judicial discipline. What is doctrine of judicial discipline? When the Honorable Supreme Court declares a law, for example, in Rajneesh versus Neha case, where the Honorable Supreme Court held that when wife seeks a maintenance from the husband, it is generally they exaggerate what is the salary of the husband. When husband is supposed to pay maintenance, he tried to reduce his income. In order to avoid this mishappening, the Honorable Supreme Court has held there should be affidavit of assets and liabilities to be filed by both the parties. So affidavit is filed. Still, if the other party finds that there is a false statement, then one who deposed a false statement can be punished for the contempt, can be punished for giving false evidence. They may be sent behind the bars. So there is a fear of law instilled in the minds of a false litigant. A statement, false statement is given by the litigant. So this is a judgment pronounced by the Honorable Supreme Court for all the courts. When family court, if they do not insist for filing of the affidavit of assets and liabilities, it is a gross violation to the judgment pronounced by the Honorable Supreme Court. The district court or the family court is violating Article 141, 144 of the Constitution of India. So therefore, they have gone against the doctrine of judicial discipline. So therefore, there may be a disciplinary proceedings also. There may be a contempt action also. It depends upon the facts and circumstances of the case. I always said, whenever we read, how do you correlate with the preamble of the Constitution? In this case, from the beginning of the preamble till the end, the one thin line which runs from the preamble till the end of the Constitution is the rule of law. So what is the rule of law here? The law declared by the Supreme Court, binding on all courts, that is the rule of law. So therefore, you always correlate with the preamble also, justice, social, economic and political. So now we have discussed about what is the leading case, under what circumstances and situations the case law, ordinary case law becomes a leading case law. Then what are the relevant provisions with respect to the leading cases, Article 141, Article 144 and then preamble rule of law. This we have done. We have successfully answered the first question What is leading case law? The second question what we have posed to ourselves is the study material, right? For that study material, dear friends, I draw your attention to regulations regarding advocates on record examination. Regulations regarding advocates on record examination. This regulation is appended to the Supreme Court rules, in which they have held the examination committee appointed by the Chief Justice of India. They are conducting examination with respect to the four subjects. One of the important subject which we have gathered today to discuss is the leading cases. So leading cases, a list of leading cases shall be made available to the candidates at the time of notification of the advocates on record examination. Now the notification has got issued, 2025 notification has come. By virtue of this, now I have got a notification with me, dear friends. This was issued on 9th of April 2025. Now, very recently, the Honorable Examination Committee has included from 65 to 86 judgments. Already it was only 64 newly added cases with effect from 8th of April 2025. It begins from 65 and it goes up to 86. So I request each one of you, the AOR aspirants, to concentrate more on the newly added cases. And you can link with the old cases. I will tell you how to prepare. So when newly added cases means it never appeared in any of the questions because it is just now added. So you can give more importance to this and you can correlate with the already earlier decided judgments. How you can correlate? So how are you going to get the study material? First study material is, please visit the Supreme Court website. Very recently we have come out with this book, dear friends, The Guiding Star of AOR Aspirants, in which we have specifically said that there are references at page 328. So what is the study material that we can get it? It is in serial number 4 I have referred. Study materials for AOR examination are available through the notices and circulars, lectures and videos, old question papers at the website of the Supreme Court of India. So visit the Supreme Court of India's website and there is a column advocates, advocate on record examination. Open that where you will find all the study materials, the relevant study materials. That is one of the sources. That is not the only source. That is one of the primary sources. Thereafter notices are there, lectures are there, old question papers are there. That is one source. Second source is SCR entire judgment with reference to these cases. Entire judgment is given. Please download those judgments one by one. Download it. And if time permits, the examination committee expects all the AOR aspirants to study all the judgments in toto without leaving anything. This is what expected. But if you say that, sir, there is a paucity of time, we could not study the entire case. Keshavananda Bharati is running to several pages. All leading cases are running to several pages. But the examination is for 3 hours only. How can we complete the entire paper within 3 hours by covering all these subjects? So when we ask those questions, we will find the answers. The study material available is from the website itself. Very recently or even a year back, they have introduced, the Supreme Court has introduced landmark summaries of the landmark judgments. That is there. Hope you all aware. Please visit that. There is a separate committee is there where they work upon that and they put it in the website itself. The committee's name is Center for Research and Planning, Supreme Court of India. So summaries of landmark judgments. So it is there, running to only 3 pages only. See, if you read the entire 300 pages, it is running only to 2 or 3 pages. So entire aspect is given. We are looking everywhere, but not the Supreme Court website. That is very important. So landmark judgments can be taken from the summary, can be taken, but that is only for the reference, dear friends. If you have any doubts, any clarifications, you have to read the entire judgment. That is what expected. Now, thereafter, in the Honorable Supreme Court of India website, there is a publication is there, Supreme Court Chronicles. Please visit, see this. Supreme Court Chronicles is there, monthly magazine. So there also the Honorable Supreme Court comes out with landmark judgments. Very sensitive issues are discussed in only 1 page or 2 pages only. If it is 2 pages in a book, if you are going to write, it will cover 3 or 4 pages. So the most important aspects are already given there. So that also you have to see and study and discuss with your friends. Yes, it is available. Yes, ma'am. That is Supreme Court Chronicles. Soft copy is available. So these are all. First is sources, read the entire judgment, or the study materials are also available given by the earlier lecturers who as examiners, the senior advocates who had already delivered the judgments, already dealt with the leading cases. They have prescribed certain study materials also. They have prepared the summaries also. That is also available in the study material of AOR examination. So what they generally say is, our sane people, what you want to see, you can see. What you want to hear, you can hear. If you want to join some dance class for to relax yourself, every time you used to go that way only. But once you make up your mind, you will find there is a dance classes going on. Or when you are looking for some rental premises, there will be a poster written over there, rental premises or PG are available. So what we are going to want, that you can see. So if you really want to see the study materials, you would have already seen the Supreme Court website. These are all things available. Have thirst for knowledge. That will definitely take you to greater heights, dear friends. This is the second source. And I will add the guiding star of AOR aspirants also. All the questions are compiled with reference to the chapterization. Most frequently asked questions are given importance. So it is available. You can purchase this also. This is very important, because that everything, though answers are not given, answers are available in our lectures. This is available in YouTube. Multiple times you can watch. And this is the questions. Most important questions are compiled, chapterized, and it will be immense help for our AOR aspirants. Now the third question which we pose to ourselves is how to prepare. When several pages, the landmark judgments running to several pages, how to prepare and how to write in the answers. Let me tell you about the preparation, dear friends. First is facts of the case or factual background. Apply this test to all the cases. Facts of the case or the factual background. Number 1. This is first heading. Second heading is issues involved, question of law involved, or substantial question of law, or points for determination. Issues involved, that is second. Third heading is decision of the Honorable Supreme Court, in which 3A will be majority view, 3B will be minority view if it is there, or unanimous judgment, whatever. So facts of the case, issues involved, decision of the Honorable Supreme Court, in which majority view or minority view or unanimous judgment, that you can write and elaborate. Once decision is given, what is the reason for the decision? That is what natural justice. When you are giving a decision, it must be supported with reasons. So ratio decidendi, reason to the decision. That is the heading, dear friends, reasons for the decision. Fourth heading, in which you will be elaborating each point. Try to write in point wise, dear friends. Don't write it in paragraph, write it in point wise. So reason number 1, 2, 3, you can point wise, you can write the reasons. Those reasons, how it has to be, how the constitutional provisions are interpreted. It is not the mere facts. Facts coupled with provisions of the constitution or the provisions of the relevant statute, and how it is being interpreted, interpretation of the constitutional provisions or the statutory provisions. While interpreting those provisions, what are the principles applied? Principles of fairness, or which doctrines applied? Doctrine of judicial discipline, doctrine of public trust, doctrine of sustainable development, doctrine of polluter pay principle. It depends upon the case to case. What are the doctrines applied? Principle of fairness, principle of legitimate expectation. And this binding precedents and judicial discipline you can apply irrespective of any questions, because it is referenced a leading case. So binding precedents is there, judicial discipline is there. So likewise, you have to prepare a common answers which can fit for any questions. Thereafter, the fifth point is my personal opinion. That means your personal opinion. What is your opinion about this case? Do you agree with the honorable judges, or do you disagree with the honorable judges? The examiners is expecting you to analytically think, and what is your say on that? Because that is how the law is developed, evolved. It is not static, it is interpreted and evolved. And the classic example is Article 21, right to life and personal liberty. Now the entire sky is covered under Article 21. Right to go abroad, right to sleep, right to clean environment, right against handcuff, and right to privacy. Now right to digital access. Everything has come, dear friends, in Article 21. Why? Because to secure to all its citizens justice, economic, social and political. Therefore, to give effect to preamble, it is implicit in Article 21. Because the Constitution of India, the protector is the Supreme Court. Supreme Court has to evolve the dynamic, legendary act, that is Constitution of India. So you can apply these headings while you prepare for your exam point of view. Maximum 3 to 4 pages, because you cannot write beyond that. Time will not permit you to write 7 pages or 8 pages there. Then you will be deprived of writing the other questions. Questions may carry equal marks. So you have to equally manage the time with other questions also. So one question you know means, that means you cannot write for 1 hour. So you have to have a time management and write maximum 4 pages, and with headings, with point wise, and your opinion. You can always say that I agree with the Honorable Supreme Court because of these reasons 1, 2, 3, or I humbly disagree with the Honorable Supreme Court judgment because the Honorable Supreme Court has ignored the basic structure doctrine which is held in Keshavananda Bharati's case, a larger bench. So in case if you find that is a lacuna, you can write down. So therefore it will impress the examiners. So this is how you can prepare for the entire case laws, dear friends, because every case evolves with the facts. So facts that issue to be determined, then what is the decision of the Supreme Court, what is the reason to the decision, with application of the principles, doctrines, statutory provisions, interpretations, and then your personal view. I think this is sufficient for 4 pages and to elaborate, and you can mold according to the questions asked. So generally when I wrote advocate on record examination, I preferred to write overview of those judgments. Sometimes the questions appears in such a way, what is the majority view, what is the minority view of the judgment, and there will be a judgment elaborate on Vishaka versus state of Rajasthan, Rupa Ashok Hura, entire judgment. Therefore you can write the entire story, facts also, issues also, everything. So I try to choose those questions, therefore I can write everything. Unless and until you know the majority view or minority view, you may be committing mistake. In entire view you can write whatever you want. And one more aspect which is most important, the examination committee will provide you head notes of SCR, Supreme Court reports. So whatever the tabular column, whatever the leading cases that you find here, you will have the head notes of those cases with index. So you can refer also. But I request you, there are aspirants which they will say that I will write copy from there and I will write it. That is not so, dear friends. You have to understand the basics, the entire judgment, and then you can take guidance from the SCR, head notes. That cannot be the only source of your answers. That is not correct approach. And even if you want to copy something from that, you make sure that you give some subheadings and write in your own way, in your own language. Therefore, the examiners will not feel that it is mere copy paste. So you give your headings and then accordingly you write. This is the art of writing. And time management is very important. So this is how you can prepare your answers and write your answers. And make sure that you discuss with other people also. The like-minded people and right-minded people. That is most important. To choose your friend, he has to sail with your boat. So with this, dear friends, we have answered the basic questions. What is leading case? What are the source of leading cases? Third is, how do you prepare and write the leading cases?